Welcome to US Immigrant Journey, Opportunities and Challenges.
Hello and welcome to US Immigrant Journey, Opportunities and Challenges with attorney Edwin Fogam. With over 25 years of experience in immigration and various areas of the law, Edwin brings a wealth of knowledge and a global perspective to his practice. I am your host, Kevin Rosenquist, and in today's episode, we are talking about immediate relatives versus family preference visas, the key differences in family-based immigration. Edwin, so great to have you back.
Hello, Kevin. How are you doing?
I'm good. I feel like we're about to talk about yet another complicated topic that is going to go right over my head, but you're going to explain it to me.
Well, I'm going to try.
It's all you can do. It's all you can do. So let's start here. What are the key differences between immediate relative and family preference visa categories in the context of family-based immigration?
Okay, the first thing to understand is that immediate relatives are parents, spouses, and children under 21 of U.S. citizens. These visas don't have any cap. They are always available almost all of the time. As opposed to that, you have preference categories. They are numbered from F1, first preference, to fourth preference, right? F1, F2A, F2B, F3, and F4. And these preference categories cover adult children of U.S. citizens, spouses and parents of permanent residents, siblings of U.S. citizens, and brothers and sisters of U.S. citizens. Now, these preference categories are highly capped, right? Only certain numbers of visas are available in these categories every year, and they have what they call priority dates. So applying under these categories, even if the petition is approved, the applicant has to wait for their priority date to become current before they could apply for either adjustment of status in the United States or consular processing to come into the United States. So those are the main differences. Immediate relatives, spouses, parents, and children under 21 of U.S. citizens, their visas are always available. Once the petition is approved, they can file for adjustment of status if it was not filed concurrently, or they can do what is called consular processing and come from abroad to enter the United States immigrants.
Yeah, we talked about the consular processing recently, I believe, on one of our last episodes. So can you walk us through the family preference categories? You started some of those, right? You sent a few of the categories. Are there more categories after that?
Oh, they're just four: F2A, F2B, F3, and F4, right? Those are preference categories as opposed to immediate relative categories. So under these are the main preference categories. These are for children or adult children of U.S. citizens, and then spouses of permanent residents, then married children of U.S. citizens, and siblings of U.S. citizens.
Okay. No, there's not going to be a test at the end, right? You're not going to test me?
We'll have a small test at the end of it, right?
I should be taking notes. How do eligibility requirements differ between the immediate relative visas and family preference visas?
Oh, it's very straightforward. First of all, all these visas, all these family-based visas, the relationships have to be established, right? The relationship between the U.S. citizen and the beneficiary, whether it is preference or immediate relative. But the main difference is that for immediate relatives, once the relationship is established, and the other aspects like the affidavit of support, eligibility criteria are met, and the visa is approved, there is no waiting time. But for preference categories, even after establishing the relationship and meeting other requirements to get the visa approved, you're still looking at the numbers. You're still looking at the cap. Some are more than 10 years in waiting, 11, 20 years, for example.
Wow.
Siblings of U.S. citizens, I think they're as backlogged as 15 to 20 years before those visas will be available for people who have gotten an approved petition.
Wow. So that's just because there's so many people who want to bring family members over and there's only so many visas available.
Exactly, because the visas for those preference categories are capped and only a certain number of visas are issued every year. These are published every week, as a matter of fact, on what is called State Department Bulletin. They tell you the priority dates of various categories from F1 right up to F4, family-based. Ironically, some employment-based visas too are capped, but we'll talk about that some other time.
Well, how do they decide? Is it just like a first come, first serve? Is it just an order of how, or are there criteria that they use to decide who gets in, or is it random? How do they do it?
Oh, well, the cap is a legal requirement. That's a congressional.
Yeah, but I'm saying like to get in.
After the petition has been approved.
Yeah.
Again, it will depend on what is called your priority date. If your petition was approved long time ago and you are waiting, then if and when your priority date becomes current, as I said, you could check it in the State Department bulletin, then you are eligible to apply for an immigrant visa based on the currency of your priority date. So that's how it is determined who is eligible to apply. Now, if your question is as to who is eligible to come in after the application, then there are other things like security, background checks, ability to support yourself, and things like that, which are more consular processing requirements.
Okay. So it's just the application itself doesn't get you in; it just gives you an opportunity. So you wait that long just for the ability to apply.
There you go. You wait that long, and then you initiate what is called consular processing when you have a current visa to apply for, and that consular process, it may not take too long. It may take 3, 4, 5 months, but there are requirements there too that you have to meet.
Wow. Yeah. So not everyone who applies is getting in.
Not everybody who applies gets in. It's not, especially now.
Yeah, especially now.
Right.
That's a good point. So when a petitioner, like a U.S. citizen or a permanent resident, like how can they demonstrate their eligibility to sponsor a family member for a visa?
Okay, it will depend what they are filing for. Now, the big one is usually spouses. For example, a U.S. citizen filing for his or her spouse will have to demonstrate a bona fide or good faith marriage, right? Good faith relationship, whether the spouse is here in the United States or abroad. And what is a good faith relationship? Well, do they have a shared life? Do they have a history of being together as spouses, or it's a sham marriage? That's for spouses. For parents, they also have to demonstrate a bona fide or a good faith relationship with that parent. Usually, documentary evidence is the initial step. Marriage certificates, birth certificates, and so on. But it doesn't end there, because there are other things that could be requested to actually show for you to demonstrate that this is not a relationship of convenience and only for immigration purposes, right? So siblings, the same thing. You have to show that you guys are siblings with your birth certificates, other documents.
Wow. It's so interesting, like what the hoops that people jump through to get their family members here. Yeah.
The most challenging one is usually a spousal relationship, a marriage. And you might have had problems that people have with that. When you fail to demonstrate a good faith marriage, declared a fraudulent or a sham marriage, you are barred from ever having any other immigration benefit. So that is a very serious thing.
Yeah. So if you get kind of caught, if you will, trying to pretend to be married to get for immigration status, then you can actually become kind of like you said, barred or blacklisted?
Yes, you are barred. It's considered a sham marriage. You are barred. You are prevented forever from obtaining any benefit.
Wow, that's quite the punishment.
That's very serious. I think there are only about a couple of things that actually happens like that. Voting or trying to present yourself to be a U.S. citizen or filing a frivolous application for asylum and so on. Very serious criminal offenses, things like that. So it's a very serious thing.
Are there any special circumstances or exceptions that might expedite or otherwise affect the family-based immigration cases?
Yes, there are a couple. First of all, there are humanitarian considerations, right? Certain cases can be expedited for humanitarian reasons. There are also policy changes that can expedite certain petitions and change of status sometimes. There are situations where a foreign national can be abroad and actually, while a visa is pending, can switch into another legal status that can expedite the process and make them come to the United States earlier than they otherwise would have.
It just takes the waiting period out a little bit?
Yes, there are some situations that can help. It can take it out a little bit.
Okay, but not a lot.
No, not well. It depends. Not a lot. Not a lot. There are too many people waiting, and as you know, immigration is highly backlogged. Not enough workers. The processing times and things like that. So expediting immigration cases are not very. It's not very easy to do that. But in some cases, when petitions or applications in the United States have been pending for too long and they have backlogs, you could use other means like a mandamus, right? A petition to the district court or to the federal court to compel a government agency to act, to make them do that. A little extreme, but sometimes it works. We've had cases where people have applied for adjustment of status and they've been waiting for 2 to 3 years. And hey, this is not normal. Yes, USCIS will say there is a backlog, there is a processing time. But if you file a mandamus with the federal court, federal district court, chances are within 60 days, the government lawyers will call and have them adjudicate those cases because they don't want to go to court to answer why USCIS has not responded.
Are you seeing less people trying to apply these days just because of the process is so long and so backlogged, or is it pretty much the same?
Well, it's both ways, and this is the reason why it's both ways. People who, let me give you a real example. There are many people who are permanent residents and have been permanent residents for more than 5 years, but were not in a rush to become citizens. With everything that is going on, then people are now rushing to be citizens because for one reason, that is very obvious, a criminal activity, if you are involved in a crime while you are a permanent resident, that can trigger removal proceedings. But if you are a citizen, it will not. You go to jail here. So that's one reason why you can see some people don't. Now, on the other hand, people who are in situations that are a little bit nebulous, that are not clear, such as appeal processes and waiting to file, they really don't want to come out at this time. They want to be careful how you're coming out and what you're actually going to be filing. That shouldn't, because that could trigger your status and bring you out and place you in proceedings when otherwise it wouldn't have. There are many people who have been ordered removed and are still in the United States and have gotten family-based petitions that have been approved. Normally, what you would try to do is file a motion to reopen your proceedings so that you can adjust your status here. But that is a very risky thing to do at this time because that could just place you in removal proceedings. And if your adjustment of status is not granted soon enough, you'll be ordered deported.
When is the best time for someone to hire you in your firm for something like these family immigration, to help with the family immigration process? Is it something that, can they do some stuff on their own and then come to you? Is it best to get to you early? Like, what do you generally recommend?
The best time to hire an attorney for your immigration matter is as soon as you think anything to do with immigration. As soon as you think that you want to have anything to do with this complex movement of papers and forms and various adjudicatory processes, as soon as you think of that, start with a consultation and just get some informed perspective. And then that analysis will tell you why you probably will need somebody to help you through. But it's always good to start early, both employment-based, family-based, even proceedings, even when you are in immigration proceedings.
Yeah, earlier the better. Makes sense to me. All right, well, thanks for joining us on US Immigrant Journey, Opportunities and Challenges with attorney Edwin Fogam. To connect with Edwin and his team, head to fogamlaw.com. And of course, be sure to like and subscribe to our channel and leave us a review. Edwin, always great chatting with you. Thanks so much.
Always great. Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.